SJC-12817, in the matter of an impounded case.
Mr. Tower, good morning.
Morning, Your Honor. Good morning, Chief Justice Gantz, Associate Justices. May it please the Court. My name is Michael Tower, here on behalf of the appellant, Dr. Doe. There are two primary issues that the Court is called upon to consider in the context of this case. The first is whether the Board of Registration in Medicine is permitted to use a criminal record that's been judicially sealed pursuant to MGL 276, Section 100C, to discipline a physician. The second related question is if this Court deems that, that the Board is in fact authorized to use that sealed criminal record, does that necessarily mean that the Board is authorized to disclose the contents of that sealed criminal record? Now, Dr. Doe submits that this Court should answer no to both of those questions, and that this Court's doing so will in no way hamper the Board's ability to fulfill its statutory mission.
Could you clarify, because I think that the Board makes the argument that, you know, he had already disclosed a lot of stuff before the record was sealed. So what about that stuff?
Your Honor, it's our position in this case that those disclosures were compelled by the Board's regulations. It is undisputed, it's in the joint facts, that Dr. Doe would have been required to disclose the existence of this underlying matter in connection with his application. And it is also one of the enumerated bases for Board discipline that if a physician fails to respond to information requests from the Board. So it would be our position that—
But that was before the record was sealed, right?
Yes, Your Honor, it was.
So that would, does that make a difference?
I think it does make a difference because it will always be the case when a record is sealed that the Court is in effect taking information that was available to the public and removing it from public purview. And so in a situation like this, where the only information that the Board of Registration has was compelled by the mere existence of the underlying criminal matter as opposed to the underlying conduct itself, we think that the effect of the Board's sealing is to remove that from the Board's purview purely for disciplinary purposes.
So let me ask you a question then.
Yes, ma'am.
Would it have made a difference if the record had been sealed before, disciplinary proceedings had begun?
So,
In the sense that, you know, if they had only the sealed record, would he have had to disclose anything?
at the time of his application, the statute had not yet been amended, so he would have been,
Even though it was sealed?
he would not at that point have been permitted to respond no record in response to, that was a change that the legislature made in 2018, authorizing no record in the face of a request by a licensing board.
Okay, so now if it was somebody in the same situation who had the record sealed, that person could answer no record?
Yes, Your Honor. And it's our position that that's really one of the determining factors. Today, this information would never have come to the board's attention unless there were some independent report to the board that caught its attention. And I think one way to
when you say this information, do you mean the incident itself, or do you mean the fact of a record?
Well, either one, Your Honor.
Because wouldn't he have still been required to self-report? Even if there had, wouldn't he still have been required to self-report to the board?
Once the record was sealed, he was...
No, before the record was sealed.
Oh.
Before there was, when he reported, which was appropriate, wasn't it?
He would have been required to report on his next application. That's correct. At that point, he would have been required to disclose the information.
Okay, but at the time that he disclosed the information, wasn't he required to disclose the information?
Yes.
Okay, so with that in mind, the board has the information.
Yes.
And they can use whatever they know apart, in your argument, apart from what was sealed. Is that correct?
It is our position that if the only information that the board receives is the existence of a criminal matter that is subsequently or even previously sealed, that is not a sufficient basis for attorney discipline. That does not mean, however, that we are asking for any limitations on the board's investigatory power, nor are we submitting that the board could not independently reprimand a physician based on independent conduct. And I think actually one of the hypotheticals, in the board's brief really makes that point nicely. The board posits a physician who makes a report to the Board of Medicine that the patient's physician, pardon me, a patient makes a report to the Board of Medicine that the patient's physician committed an indecent assault. Now, in the board's hypothetical, that the concomitant criminal matter is dismissed and subsequently sealed. Now, without attempting to fight the hypothetical, I think it's important to remember that under 100C, that sealing only happens after an individualized judicial inquiry, taking into account all of the factors that this court laid out in Pond, with the full participation of the Commonwealth through the DA and all the associated appellate rights. But assuming in that hypothetical that it was sealed, the board would nevertheless have an independent basis to investigate and discipline the underlying conduct, that is the report of the patient. And if the board subsequently was going to publish the results of its investigation or its order, it could recite its entire basis for discipline without ever even referencing the underlying criminal matter.
But are you saying that they could not do that based on self-reporting?
I think to create a scenario where the legislature clearly contemplated that there would be applicants with sealed criminal records. That's baked into the statute. Otherwise, there would be no reason for the legislature to have authorized the no record response. So it's our position that if the only information that the board has relates to the existence in and of itself of the sealed criminal matter and any concomitant compelled disclosures to the board of that matter, once it's sealed, that becomes off limits. So in this case, nothing in the record suggests that the board has independently developed any information aside from these compelled reports. I think it also points to another concern that we have with the board's statutory construction scheme. That is, we do not believe that it properly harmonizes these statutes or comports with legislative intent.
But what do you do with the board's argument that 100C doesn't prohibit its use, and we have the language in 100A and 100B that's more specific?
Well, I think that there are a few problems with that argument that could lead to absurd results. So baked into the board's argument is the notion that people that travel under 100A are somehow worthier of enhanced protections than those under 100C. And we think that that runs counter to legislative intent when you look at both the substantive and procedural tenets built into the statute.
Let me follow up on that point for a minute. With 100A and 100B, the language is basically the same with regard to not using it, somebody not using the information that's sealed. It's basically two sentences. But when you get to 100C, it is permitted for some reasons, but not for others. It's not like they just totally omitted or forgot to include that reference. They did in 100C refer to somebody not being able to use it, but they specifically did not mention licensing agencies.
I of course agree with Your Honor that use language is not in 100C, but I think there's a relative.
But it is you agree it is for other types of employers or other agencies or something. It's just excluded for licensing.
Yes, and I think that can be explained by noting that 100C is never available for someone who has a criminal conviction. It's only available for people whose cases, like our clients, was dismissed, for example, which is one of the reasons why we think it's suspect that the legislator intended to grant enhanced protections to people who actually had criminal convictions as opposed to those who didn't. But with regard specifically to the missing language, I don't think there was any reason for the legislature to ever think that the board would use a dismissed misdemeanor as a base for physician discipline. And in that regard, we reference in our brief what I consider to be a nearly identical argument advanced by the Attorney General's office in Wing versus Commonwealth. The question there was, can a criminal defendant access sealed records of the victim for purposes of impeachment? And in the brief, which we've supplied to the court, the Attorney General took the position that the impeachment statute speaks only to convictions. And so because of that, there was no need for the legislature to include the use language in 100C because it never involves convictions. It only involves cases like ours that were dismissed or null prost. So we think that that demonstrates why the legislature didn't need this language in 100C. When you look at the board's statutory and regulatory bases for discipline, it refers to convictions. The statute refers to conviction of a crime that calls into question the physician's ability to practice medicine or competency to practice medicine. In Borum's regulation, it's reserved for itself even broader authority, authorizing itself to discipline physicians based on the conviction of any crime. But it does still require a conviction. So when a legislator looks at that statutory and regulatory scheme, there's no reason for it to even occur to that legislator that a dismissed misdemeanor claim would serve the basis for board discipline.
Does it matter that 100C, if I'm remembering correctly, that 100C doesn't have a time period before they can be sealed? In other words, before you can have access under 100A and 100B to misdemeanors and felonies is a certain period of time. But 100C, even though it's dismissal, would be available for immediate use, presumably.
Just so, Your Honor, and in fact, I think that actually argues a bit in our favor. In addition to our suggestion that the legislature would not have intended enhanced protections for those with criminal convictions as opposed to dismissed cases, it's also important to look at the administrative scheme or the procedural scheme. Under 100A, it's merely a question of paperwork. There's no discretion or individualized judicial scrutiny. The criminal defendant basically fills out a form that represents that a certain period of time has happened since the underlying convictions with no further criminal difficulties. That goes to the Commissioner of Probation. The Commissioner of Probation queries his records, and if the information is correct, the records are sealed, period, full stop. Under 100C, however, the legislature required a much more strenuous process. 100C requires that that criminal defendant go before a judge and carry the burden under the criteria that this court identified in Pond of proving that the interests of justice are best advanced by sealing that criminal record. And that is another reason why we contend it simply defies logic that the legislature would have intended lesser protections for those who actually are subject to individualized judicial scrutiny as opposed to those who are simply filling out paperwork based on the passage of time.
So your argument is that when you go to a judge and you get a order to seal, that even though the board independently and with no wrongful conduct on its part has knowledge of wrongdoing which may potentially be the subject of discipline, that they cannot proceed with that because you have now the order to seal?
That's not quite the position. Our position is that if the board has information that is truly independent of the criminal matter and the process, police reports, court documents, the board is perfectly authorized to investigate and, if appropriate, discipline on that basis.
But you agree that the board did nothing wrong. Your client was obliged to report what he reported, and it was appropriate for them to question him with regard to it, and whatever they obtained in that regard involves no violation of any court order.
I'm not accusing the board of any impropriety. No, Your Honor.
So the board now is supposed to, has this information, but now is barred from using it because you got an order to seal.
I think that...
Isn't it, I mean, we don't have, an order to seal does not necessarily require all those who may have had information of the crime to not act upon their own independent knowledge, does it?
Well, I think in this case, when the only source of that knowledge flows from the existence of a criminal matter, it does. And I think that, to take another example, the board has taken the position, which we contest, that it's a criminal justice agency and therefore is authorized to access sealed criminal records.
Put that aside. Put that aside. I'm not sure that I'm persuaded by that, given that that was done before the legislature made it pretty clear that it doesn't necessarily want them to have access to it. But the order to seal which you got was done without notice to the board. The board had no opportunity to go to the judge and say, substantial justice would not be served, Your Honor, because we intend to proceed with discipline based on this, and if you are, according to the argument of Dr. Doe, if you were to grant the order to seal, you will effectively be preventing us from pursuing discipline. Shouldn't the judge have had the opportunity to consider that in deciding whether to seal it?
Well, I think that the judge did. The interests of the Commonwealth in this case were represented through the District Attorney's Office, and the record at 112 also reflects that 2 Assistant Attorneys General also entered appearances. In addition, on the
Is there anything in the record which indicates that the judge was aware that the board was contemplating discipline on the basis of the now sealed matter?
I don't believe there's anything in the record, but when Dr. Doe disclosed the fact of the sealing, there were still, by my calculation, 11 days left for the board to move for reconsideration or to appeal the order. So the board has never explained why, even though it had that opportunity to challenge the order after it learned about it, it never did so.
Do you take it that the board has changed its position in any way since the beginning of your suit before us? I mean, does the board still take a position as far as you're concerned that it must report?
The board appears to have abandoned that position. The board does not. It appears based on the brief that the board no longer takes the position that it has authority to publicize the information regarding the regarding the sealed matter during the pendency of the proceedings. It appears to still take the position that if it renders final discipline, it can disclose the sealed criminal information. And as we addressed in our brief, its statutory basis for that we think is quite shaky indeed. The statute requires the board to create profiles of physicians that describe final board actions. And it's our position that the board could fulfill that statutory mandate without violating the sealing order by simply identifying the physician, the date, and the type of reprimand. In other words, the statute does not require disclosure of the underlying information, nor does it seem to authorize it. So in the face of a binding judicial order sealing the records, it is our position that it would be inappropriate for the board to unilaterally abrogate that order and unseal the records.
Okay, thank you.
Thank you, Your Honors.
Thank you. Ms. Green.
Good morning, Your Honors. May it please the Court, Assistant Attorney General Julie Green for the Board of Registration in Medicine. The Board of Registration in Medicine is charged by Chapter 112 with regulating the practice of medicine in the Commonwealth, and that statutory mandate includes, under Section 2, ensuring that licensed physicians are of good moral character, and under Section 5, with taking action on reports of physician misconduct, imposing discipline where warranted, and informing the public, disseminating to the public information about final disciplinary actions.
So along those lines, if the appellant was correct, is correct in the argument, what if the board has information independent of a disclosure? They have information from witnesses, letters, that there's this doctor's fraudulently or improperly prescribing medication. Under the appellant's argument, would you not be able to do anything with that information?
No, the board is charged by Chapter 112 with taking action on that information.
I understand
Absolutely.
that. I understand that, but would you still be able to do it if the information was sealed? If there was a conviction for improper prescribing of medication, and at the time the board is looking into this, it's sealed. If the appellant wins, could the board not use that information?
So to make sure I'm understanding your question correctly, if it's a conviction, it would be sealed under Section 100A. And in that case, there is explicit language prohibiting board use of a sealed record. So to answer your question, it would depend, I think, what the information is. The prohibition, the plain language of the prohibition extends only to such sealed records. So the board would be prohibited from using the sealed record itself.
What about a dismissal under, or a not guilty under 100C?
Under 100C, there is no explicit prohibition.
I understand that, but
So in that case,
that's your statutory argument, and just for the sake of my question, assume that that's not successful, and we take the appellant's position. Would you be unable to use the independent information under their position?
no. we would be able to use the information if it's independent of the sealed record. So assume you read into 100C the prohibition from 100A. The board would still be able to take action on information gathered from other sources, not relying on the sealed record itself. Obviously, there is a continuum of evidence that the board gathers. So on the one hand, there's the sealed record itself, or perhaps a photocopy of the sealed record. But there's also the doctor's own self-disclosure, as in this case, before the record was sealed. There is information reported by third parties, victims, hospitals, mandated reporters who provide information directly to the board. If the doctor had been arrested, that could have been covered in the local paper. The board monitors news and receives reports on physician misconduct through that mechanism. Another way that the board receives information about potential physician misconduct is by monitoring court records. So records of court proceedings, long before any sealing could occur, would come to the board's attention that way. These are all sort of different mechanisms for the board to investigate and take action on reports of physician misconduct, and to take the position, to adopt the doctor's position in this case, that the use prohibition extends beyond the plain language that the legislature enacted into a sort of a vast swath of evidence about physician misconduct, would really, I think, be to tie the board's hands in a way that is not supported by the statutory language, and that would really disserve the patient safety mission of the
What
board.
would you take the language then to mean about using it?
So the
Is it in
use
licensing?
prohibition of Section 100A says use of such sealed records, and in that
Okay,
case,
so what do you mean by that? What do you take that to mean, I guess, is what I'm asking.
It also says admissible in evidence. I think it's akin to admissible in evidence. I think it would be reliance on the fact of the sealed record. But if, on the other hand, the board sits down with the doctor and says, okay, tell us what you did, what happened, in that case, that would be separate and independent information. The board wouldn't need to rely on the fact of the record itself.
And you focus on the legislative language, but there's new legislative language, which now says that if he had been a medical student when this happened, and if the record had been sealed at that time and he were to apply to be a doctor, you would have on his form that you should answer no record if your record was sealed. The legislature clearly wishing that not be the basis to prevent him from serving as a doctor. So I understand that was in 2018, and that was before that. I understand that you have this information independently. But how do you understand the mission now of the Board of Registration in view of this new legislative mandate? You focus on the legislative obligation that you have to protect individuals who are receiving medical care, but now you have another more recent legislative mandate. How do you marry those two?
There's no question that there's a tension. They're serving two different purposes. At the end of the day, I think that the sealing statutes in Massachusetts are a creature of statute. The sealing benefits are a creature of statute. It is not, as in some jurisdictions, an equitable remedy of uncertain contours. The sealing statutes give precisely the benefits that they give. In this case, the legislature was tasked with striking a balance between two fundamentally competing interests. As this court recognized in Commonwealth v. Pond, there is the public safety interest in ensuring that the public has access to information about criminal history, and on the other hand, there's the rehabilitative interest in permitting licensees a clean start. So the legislature served one interest in part and another interest in part. And the result is a compromise. It is perhaps not entirely satisfying to everyone, but it is a permissible and rational legislative choice. And the legislature could not have been clearer about the language that it chose in doing so.
Can I follow up on that question, though? I mean, it seems to me that the board would be treating the doctor differently if this had happened after the legislation than preceding it. Is that not so?
That would not be the case on these facts because Dr. Doe didn't have his record sealed at the time that he had to file his license application.
So he would not have been able to answer no record even if he got it sealed afterwards?
Exactly right. So the distinction that now exists as to everybody to whom the amended version applies is simply a distinction between those who've gotten their records sealed and those who have not.
All right, so assume that you've gotten your records sealed. What does it mean in terms of how you proceed now
If Dr. Doe had his records sealed at the time he filed his application under the amended statute, he could have answered no record.
Okay, and then what would have happened?
It would depend. If the board had no other information, it would have no basis to discipline. It would simply be unaware of the events.
Okay.
If, on the other hand, the board had learned of the information through independent means, it could take action. So, for example, if the arrest had been covered in the local paper, if the board had the court records, if the board had checked the court records during the lengthy period before it was sealed,
So any information that was gotten independently could be used, you're saying?
could be used.
Even though it was the same information that would have been sealed?
That's correct. And that's simply by virtue of the language of the statute.
And what's the consequence? So let's assume that you proceed, let's assume that we permit you to proceed with discipline, and let's assume that you decide that some discipline is appropriate. When I go on your Board of Registration site for Dr. Doe, what will I find? And what would be the consequence of the sealing order on what I will find?
What you will find, assuming final discipline is entered and not, reversed after judicial review, there's a physician profile, and in it, there's a section relating to discipline, and you'll find the actual sanction that was imposed, and there's a separate section devoted to disciplinary action in which you will find the final order entered by the board. And so if you'd like to see an example of what that looks like.
I've already gone on your website to look. So it'll say censure, if that is to be the discipline, correct?
Or reprimand frequently.
Okay, but then you go on the website, and then the statement of allegations, there's a PDF. Do you intend, in this particular case, to publish the statement of allegations?
The board's practice, as I understand it, is not to publish the statement of allegations itself, but rather
I
the
saw it.
final disciplinary
No,
action.
I saw it last night. I went on and I plunked in and saw another doctor's 2019 statement of allegations.
Yes, that's correct, and I think it varies from case to case. I think my understanding is that when there's a final written document, a sort of final disciplinary decision, the board opts to produce that. So you could see it, Record Appendix 143 is a nice example of one of those.
Okay, so
When
let's go back to my hypo. And again, as to whether or not discipline's appropriate, that's not before us. The only question is whether whether the board has the possibility of proceeding with discipline in this particular matter. But let's assume, for the sake of argument, that we do permit you to proceed with discipline, and there's a finding of censure. Is it your intent, in view of the sealing of the order, for there to be a statement of allegations that would essentially make public all that has been sealed?
Potentially, yes. To make public certainly the essential basis for the discipline and the facts necessary to apprise the public.
And how is that in keeping with the legislative mandate with regard to the sealing order? You will now have made public, effectively, all of the information which a judge has ordered sealed after a finding that substantial justice would best be served by the sealing.
So the answer is that the benefits of sealing are only those that the legislature prescribed by statute, and it's not a hermetic seal. And for a certain subset of individuals, those who choose to become licensed physicians, when they engage in misconduct that is independently potentially subject to discipline, even notwithstanding a seal, nothing in the sealing statutes prohibits the board from taking action and from publicizing that information about what the basis for the disciplinary action
Now,
was.
I look to 112, Section 5, and it requires there to be a description of any charges for felonies and serious misdemeanors as determined by the board to which a physician pleads nolo contender, or where sufficient facts of guilt were found and the matter was continued without a finding by a court of competent jurisdiction, which of course is this case. Is it your view that you would be publishing that information even though it's sealed?
Potentially, yes, and I actually would refer you to the item a couple notches down that refers to a description of any final disciplinary
That's
action.
only one notch down, but that description of any final board disciplinary action could be done simply by censured.
It could, and the board certainly has discretion in how much detail to
Right,
provide
so
to
you're
the
not, the
public.
statute does not oblige you to include the statement of allegations. It obliges you only to describe the final sanction.
I think there is discretion in the board. It is the board's practice and policy that to say that a physician has been disciplined without saying why would disserve both the interests of the
Well, I
public and the
understand
physician
that,
herself.
but do you have a practice or policy when it's a criminal matter which itself is sealed?
Nothing specific to sealing. The general policy would be that public transparency is important, it's essential to the board's mission, and to say, censured or reprimanded without saying what the problem was would be to disserve the patient interest in selecting a physician in whom the patient can repose trust and confidence.
Okay, so when we are seeking to marry the language of the Board of Registration statute with the language of the sealing statute, what do you say we should do with regard to the amount of information that you make public? Allow you to do what you do in your discretion, including a statement of allegations, or limit the information which you are permitted to furnish to the public lest it negate the order to seal?
There doesn't need to be any marrying in this case because the sealing statute itself doesn't contain any prohibition on either board use or dissemination. The sealing statute gives only the benefits that it gives, and that is not among them. It is certainly open to the legislature to make a different policy choice, but it hasn't done so.
And can you may have answered this already. I'm sorry, if I interrupted you. You may have already answered this and I missed it, but what do you think the rationale is for the difference in section 100C versus the other two sections?
So I can only speculate about what was in the legislature's mind, but I see a couple of distinctions. First, 100A sealing is only available after a substantial lapse of time during which the individual has to show a sustained lack of recidivism. This is based on evidence that was before the legislature that sustained period has predictive value for the future. That lack of recidivism, the time lapse, isn't present in 100C. A 100C sealing is made on a discretionary, inherently predictive decision by a fallible human being, and therefore there may be need for a licensing of the public safety agency like the board to take action. There's a second difference, which is that sealing under 100A doesn't occur until the record has been publicly available, at least unsealed, for a substantial period of time. So the Board of Registration in Medicine, in any case where a physician is already licensed, will have already received information about a conviction subject to sealing under 100A because the license renewal cycle is every 2 years, and sealing under 100A isn't available until at least year 3. So there's a substantial period of time during which that information is available fully for use by boards and commissions, which is not the case in C, where the record can be sealed on the immediate next day.
Now, you made reference to the public records law,
Yes.
which would limit the disclosure to an individual who sought information regarding Dr. Doe.
So, yes, and if I could clarify our position, we have altered our position since the single justice briefing, and I can certainly
Help me
explain
to
what that
understand
is.
where you were and where you are now.
Thank you. So, at the time of the single justice briefing, it was our understanding that the public records law would compel disclosure of all records of pending disciplinary proceedings, that is, before final board action, in response to a public records request. We have since revisited that legal analysis and concluded that exemptions to the public records law would potentially apply, such that certainly in the case where there's a sealed record, that compelled disclosure via the public records law would not be required. That then gives rise to a follow-up question, which is, well, what disclosure would the board make absent the legal compulsion of the public records law? And there we've submitted an affidavit, which I recognize is an unusual thing to do, but we did want the court to have before it information about what the board's practices are with regard to public disclosure. And the answer in that case is Dr. Doe has available to him, and the board will, upon request, impound all records relating to disciplinary proceedings up until final discipline is entered, and for a period of 10 days thereafter to give the doctor an opportunity to seek judicial review.
Wouldn't that have foreclosed the ability to seek 2113 or the proprietor seeking 2113 review? I mean, wouldn't it,
I'm sorry, I couldn't hear.
wouldn't have been necessary, right? If you'd taken that position ahead of time, this whole thing wouldn't have been necessary, would it?
It certainly would have been postponed until
Right.
final
Right.
judicial review of final discipline. That's correct.
Okay.
And we are trying, this is a new phenomenon, seeking sealing during the pendency of disciplinary matters. We are trying to get to the right and best practices.
Okay, so you say it would be, your proposal is that if you take disciplinary action, it will be, you'll wait 10 days before you go public with it. So they can seek an order of impoundment. And what would be the argument with regard to why that should be done by a judge as opposed to by us when we are deciding this case?
So this speaks specifically to the doctor's claim that the board lacks substantive authority to discipline a doctor for these particular
Right, well,
allegations.
that's a separate issue, but
And so our position is the court need not reach that particular claim because that claim can be effectively addressed on judicial review of
right,
any final action.
I understand that, but the issue of basically you saying you will go ahead in the board's discretion, not because the legislature mandates it, but because the board in its discretion intends to publish it unless they go to court and get some order. But you anticipate then that a court has the authority to order you not to do so?
Yes, I think the court could enter a stay of disclosure as a matter of its equitable injunctive power pending judicial review. If the doctor shows a likelihood of success on the merits, the court could order a stay of discipline and disclosure.
And after judicial review, assuming it's affirmed?
At that point, I think the board would have power to disclose, assuming it's affirmed.
Okay, thank you.
Thank you, Your Honor.